Why don't we go ahead and get started? Thanks everyone for joining this webinar on estate planning for the here and now. We're recording the webinar today so that if you want to refer back to it, you are able to do so. We are going to be posting it to our website. That's elderlawgroupwa.com. So today what we're going to be talking about is something that may be on your mind, especially in this healthcare crisis involving COVID-19. Families are really struggling right now. There is a whole lot of uncertainty. And so we're all just trying to make sense of this world that we're in right now. So different than it was just a month ago. I know we are all trying to do what we can. We're all trying to do our part. We're all trying to help out however we can. And this webinar is one small way that I can help contribute because what we're going to be talking about are some really important matters, especially when it comes to healthcare. So what we're going to be talking about today is if you or a loved one needs medical treatment, what do you need to have in place? What actions do you need to take before perhaps you or a loved one is in the hospital? What conversations do you need to have? Not just the legal documents, but what conversations should you have with your healthcare agent? Should you have with your family? You know, these aren't fun questions, but these are serious times and they're serious questions. And I think we all are trying to do our part to be responsible and to help guide, our loved ones and help put into place things that we need so that we don't add to the confusion. So I'm a lawyer. I am not a doctor, so you will not get any medical advice here. For that, turn to your doctor, your local health department, the CDC, and of course, Dr. Anthony Fauci. But I can give you guidance about legal documents and how healthcare decisions impact a family. So what's really important is that you give this some thought before you or a loved one might end up in the hospital. So my name is Lynn St. and I am an elder law attorney, and I've got 34 years of experience. One thing I wanted to mention that we are going to be answering your questions towards the end of the webinar. So if you, if you can scroll down to the bottom of your Zoom screen, you'll see that there is a place where it says chat. And so feel free to do chat. What that means is feel free to ask questions so that I'll be able to answer your questions toward the end of this webinar. All right, so hold on while I go to the next screen here. All right, so as I mentioned, I've been an attorney. I've been an attorney since 1985. I graduated from the University of Washington School of Law. That Juris Doctor degree, what that means is that's a law degree. I'm an elder law attorney, and so I am a member of the National Academy of Elder Law Attorneys. I'm a member of the Washington Academy of Elder Law Attorneys, and I've been on its board. I've been its former president and its former member of the year. AVO is a rating service, and I have a 10.0 superb rating from AVO. Martindale-Hubbell is another rating service with an AV rating. And I also have been named since 2008 as top elder law attorney in Washington by the Spokane Coeur d'Alene magazine. So that's just a little bit about myself. So telling you a little bit more about Elder Law Group. This is an older photo. The ones of the dogs is fairly current, but we have a team of dedicated legal professionals. The yellow lab is Piper, the chocolate lab is Willie. They are just kind of our canine companions that we have here. So that's a little bit about us. We have an office in Spokane, we have an office in the Tri-Cities, and we do serve North Idaho as well. All right. So with COVID-19 on everyone's mind, what I want to do is share with you information that will help you be better prepared from the legal point of view, but also from a personal preparedness point of view. Some of you probably have already dealt with important decisions that perhaps you've had to make on behalf of a loved one. Maybe you haven't. If you have, you know that it's better to have more information about the situation, not less. And by that I mean, you know, having some difficult conversations. So being a lawyer doesn't necessarily make me qualified to talk about health crises, but being the adult daughter of two aging parents does. So here is why I do what I do and why I want to share information. As some of you may know, we do a lot of presentations in our community, but with COVID-19 and the stay home, stay healthy, this is how we can help share information. So what you're seeing here is Bill and Sarah St. Louis, and at a time when they were healthy, and then the later slides tell you when they weren't quite so healthy. In about 2002, my dad suffered his first stroke, and his health declined after that. So we actually did have a situation with my dad back in 2006 when he had a heart attack. He was in ICU and he was on a ventilator. And one of the questions that the family had to answer was, okay, well, if we take your dad off of this ventilator and he can't breathe, do you want us to re-intubate him? Which was not a question that had ever crossed our minds before. Fortunately, we didn't have to answer that question because when they took him off, he was able to breathe. His quality of life after that was severely compromised. You can see the picture with him in the wheelchair of my mom. He needed 24/7 care after that ICU stay, but he did live for 4 more years. My mom, she was a registered nurse, and as a part of taking care of dad, even with a lot of help, she also suffered a stroke in 2010, and then she later needed 24/7 care, and she passed away in 2016. So I share this with you because this is the reason why it's important to me to share as much information as I can to help families prepare. Because if you've ever been through a health crisis or you've dealt with long-term care, you know it's really, really difficult. And the more we can do to help ourselves and our loved ones, just being prepared, having conversations, I think it's really important that we do that. So what we're going to be talking about are legal documents, the legal documents that you need to have in place in event of a healthcare crisis. So think of it this way. If you're the patient and you can't communicate, who is speaking for you? Or maybe you're not the patient, but your loved one is in a health crisis. Who is speaking for your loved one? Who will the doctor talk to? Who will the doctor take direction from? These are questions that we need to have answered and we need to be prepared for in advance of any kind of health crisis. So, you know, as an elder law attorney, what we really focus on is estate planning, but with you know, the realities of how estate planning impacts people as they age or deal with health crises or long-term care crises. And so I can share with you what I have learned and is also what I have experienced firsthand in my own family going through medical emergencies. So here's the main things that I want you to take away from what documents do you need in advance of a healthcare crisis. You need to have, number one, your healthcare durable power of attorney and your healthcare directive. Those are the 2 most critical documents that everyone should have in place at this point in time. So I call these documents living documents. And the reason I call them that is that these are the documents that protect you while you are alive. So the healthcare durable power of attorney is a document that is there to protect you while you are alive, as is the healthcare directive, which states your end of life wishes. There's also a financial durable power of attorney that is an important document to have in place. We're not going to spend so much time on that today, but I do want you to know that your financial durable power of attorney also needs to be in place. The reason it's called durable is that this document, the durable powers of attorney, remain in place even if you lose capacity. And basically what that means is if you can't make your own decisions or take care of your own affairs, somebody else has to. And the document, the durable power of attorney, is the document that remains in effect even if you lose capacity. So it allows somebody else basically to manage your affairs. So let's focus on the medical healthcare durable power of attorney. So what is it? And why is it called healthcare or medical durable power of attorney? The reason that I am on the slide have both names is that you hear it called both things. They mean the same thing. Healthcare durable power of attorney is the same thing as a medical durable power of attorney. So don't get confused about that. They mean the same thing. So what it is, it's the legal document that you sign that gives authority to someone else to act on your behalf when it comes to your healthcare decisions. That is called your healthcare agent. So let's break that down. So when does this document come into play and how does it work? So normally the doctor will speak directly to you as the patient, but if the doctor can't speak directly to the patient, the doctor, because let's say the patient is too ill to speak or they're in a coma or for whatever reason they're not able to communicate their wishes, the doctor has to speak to someone. There has to be someone who is representing what the patient would want. So, you know, you can imagine the situation where perhaps there's 2 courses of treatment that the doctor might recommend. And maybe one of the courses of treatment is more aggressive and it might have a better outcome, but it's riskier. And then perhaps there's another course of treatment that's not so risky, but the outcome, even if successful, is not going to be the best outcome. And the doctor is going to say, all right, here are these options. Which do you want? Well, the patient can't speak for themselves in this situation. So there needs to be somebody with legal authority to speak for the patient. And that person is called the healthcare agent. The healthcare agent is the person named under the durable power of attorney for healthcare to speak on behalf of the person who signed the document. And the person who signed that document is called the principal. So those are the terms that we use with it. But that's how the document works, the healthcare medical durable power of attorney. Now, why is it important? And I think we touched on this. The reason it's important is because you, if you are the patient, or you, if you want to make sure your loved one is receiving good care, there needs to be somebody who is a trusted individual to speak on your behalf. You don't want somebody making decisions for you who doesn't know you. The person who is your healthcare agent is going to be your voice, and so what that means is they need to know what your wishes are. They need to be able to give clear direction as to what your treatment preferences would be. And when it comes to a healthcare agent, one of the reasons it's so important to pick the right person, somebody who knows you, somebody who you can trust, is they might have to make some really tough decisions, especially when it comes to end-of-life decisions. So what really comes down to is, well, one of the main questions and difficulties people have when they're when I'm talking with them about their healthcare agent, they say, well, you know, who do I name? Usually the person named is either a spouse, or if there isn't a spouse, then maybe the adult child, you know, some family member. And when it comes to naming family members, you have to make sure that they are capable of making decisions. You don't want to name somebody who's just going to fall apart and just be immobilized and they can't make the tough decisions. So you want to name somebody who knows you well and who is capable. Doesn't have to be a family member. Most of the time when we talk about the healthcare agent, we do talk about family members, but it could be, for example, a friend. You could have a situation where your friend knows you better than anybody else, and that friend is capable. That's the person then that you would name as your healthcare agent. Sometimes clients say, well, I don't have a family member. I don't have a friend that I would want to put this burden on. Who can I name? So there are professionals, they're called aging care managers, and aging care managers are people who are usually nurses and social workers, and they are professionals. And so that is a choice as well for people who do not have a family member or a friend that they're comfortable with naming. So when it comes to naming someone, you want to name someone in the first position, but then you want to name a successor or somebody in the next position. So imagine the situation, it's a spouse, husband and wife, for example. So like if I name my husband as my healthcare agent, what if he and I are both in a car accident? Then who's going to speak for me? So we're going to want to have somebody else named after each other. And in our situation, it's our adult daughter who would be the person to speak. And then after that, we have, our son who is named next. So it's a good idea to have people in a successor order. Sometimes families or clients say, but I want my family to all talk to each other. So I want to name them all as joint decision makers. And I will have a conversation explaining, I know you want your family to talk to each other. It's really important that they do. And they likely will, but don't make it a committee. Do not have co-agents named. If you have co-agents named, what happens if they can't agree? If they can't agree, then that just adds to the confusion that could even result in a guardianship. And one of the reasons to have a healthcare agent is so that your doctor has a designated point person. Who do I talk to? Who is the decision maker? It's really critically important that there be one person who's capable, competent, and qualified to serve as your healthcare agent. So I just really briefly want to talk about guardianships. A guardianship is a court-ordered process that is what is needed when there is not a healthcare agent named and when there is no decision maker. So what happens is that the court is petitioned because the person is no longer capable, so they're considered incapacitated. The court makes a declaration of incompetence. They become a ward of the court. It's really a complicated process. It's invasive, it's expensive. There's reports to the court that have to be made every year about personal care, etc. Really, it's something that if you can avoid, please avoid a guardianship. And how that can be done is basically by having good, durable powers of attorney. So HIPAA. HIPAA, you probably all heard about HIPAA. I just noticed that there was a few other things that I want to cover. So let me go back. Or actually, I'm going to stop screen sharing for a moment because there's a couple of things I want to get into before I talk about HIPAA. So I don't have slides on these. So what I want you to be aware of is that sometimes people have questions like they say, okay, well, I did go to the hospital or the doctor's office because there was a surgery and I didn't come in with a healthcare power of attorney. And so what happened was my doctor or the hospital just handed me a form. Yes, they will do that. The reason that they will do that is that they need to have someone who will be able to speak on your behalf. So the hospital or the doctor, if it's a scheduled surgery, they'll just give you a form to fill out. So why do they do that? Well, of course, because they need to have somebody who will speak on your behalf so that they can avoid a guardianship, they can avoid the confusions, they can avoid all of that. But having the physician or the hospital provide the form isn't something that's going to be possible if it's a medical emergency. See, if it's a medical emergency, then you can't sign the form. So if you do have this kind of a form from the hospital from a prior visit, okay, take a look at it. What does it say? Does it reflect your wishes? The form really wasn't provided to help you. It's not part of good estate planning. It was kind of just to cover the hospital's needs at that time. So it's not a substitute for good estate planning, and it's not a substitute for having, a healthcare power of attorney that's one that you want to carry forth into future situations. Another thing that sometimes comes up that I think it's important to mention is that, and this gets into the HIPAA situation, but sometimes, people are they're not married, but maybe they've been together for 2 years, maybe they've been together for 20 years, and they consider themselves a couple. And that's how everyone sees them. But what if that one person in the couple is sick and they go into the hospital? Unfortunately, the other partner, the well partner, the one not in a hospital, has no legal authority, not just to find out what's going on about their loved one. They cannot speak on behalf of their loved one. I mean, they are excluded from having any ability to know what's going on with their loved one, unless, of course, there's some other family member that will fill them in. And so that really causes a lot of problems, a lot of frustration when couples simply assume, wait, we're together, that means the doctor will listen to me and I can know what's going on with my loved one. That's not how it works. So especially for people who are not related, or not spouses, and you're not a child of the person, an adult child of the person who needs care, if you're just a friend, a committed partner, you need to have legal authority to know what's going on with your loved one and to speak on their behalf. All right, so I am going to see if I can go back and share my screen with you again on HIPAA. All right, hopefully you can see that now. All right, so HIPAA, this is medical privacy. You've probably seen them and filled them out every time you go to your doctor's office. There's a new updated HIPAA. Without getting too technical, this is for to keep your medical information private. So your doctor wants to know, well, who can we share your information with? And so if you haven't filled out even a HIPAA form and you're in a partnership with someone and not married, this is the type of situation where they can't even find out what's going on about you. So a HIPAA is a form. You typically fill it out at the doctor's office. What I want you to know is that a HIPAA authorization should be in every durable power of attorney. So any durable power of attorney you have or you get from an attorney has to and should have a HIPAA authorization. All right, so that's pretty much for healthcare powers of attorney. What I want to talk about now is healthcare directives. So it's called a healthcare directive, it's called an advance directive, it's called a living will. Those all mean the same thing. Again, there's a lot of names, but it is the same legal document. I find the term living will to be the most confusing because it has absolutely nothing to do with your will. So we're going to use the term healthcare directive to avoid confusion. So what it is, a healthcare directive is a legal document that you sign where you state in writing what your wishes are regarding your end of life medical choices. A healthcare directive generally is what comes into play when, you know, the doctor has said you're terminal or you're in a permanent vegetative condition, and of course you're unable to communicate. So it says in writing what you would want. So is it important to have a healthcare directive? Well, of course, yes, it is important. Let me explain why. Your healthcare agent is going to be speaking for you, but what are they going to be saying? Now, you've had a conversation with them, hopefully, I mean, a really serious conversation, but have you put in writing what your wishes are, especially when it comes to withdrawal of treatment? One of the things that we find is that the medical profession doesn't usually undertreat, they overtreat. And it totally makes sense. I mean, they're going to do everything possible to save your life and to bring you back to a good quality of life. And that's what we want. But the healthcare directive, if you don't have a healthcare directive and somebody is just speaking on your behalf because you're a healthcare agent or, you know, they're your spouse, if they have any doubt, they probably are going to recommend or authorize more treatment than maybe what you would want. So one of the reasons to have the healthcare directive is so that you put in writing, if you want no heroic measures, that is very helpful to alleviate any guilt that your healthcare agent may have when they say, no, don't treat, don't put them on a ventilator, for example, or if they're on a ventilator and they're not improving and it's clear that the outcome's going to be terrible, remove the ventilator. So a healthcare directive is how you can help your healthcare agent make the right decision and not feel so guilty about what they're saying. So sometimes people get confused because we've been talking about a healthcare directive. Before that, we were talking about a healthcare power of attorney. So it's confusing. Are these different documents? Yes. So it's basically the difference is your healthcare power of attorney is where you name someone to speak on your behalf. That's your healthcare agent. They're the ones who's going to be speaking for you. Whereas your healthcare directive is where you have put in writing your end of life wishes. If the doctors have said, and they put this in writing, that you are terminal or in a permanent vegetative condition and no treatments that they can offer are likely to make you any better, that they would be futile. So that is the difference between those two documents. So when it comes to your healthcare directive, you're going to want to put in it specific directions. And sometimes people just say no heroic measures. And some healthcare directives will be a little bit more detailed than that. For example, in our healthcare directive, we put a little bit more instruction, and it says, for example, you know, if I am in such a compromised position due to cognitive decline, stroke or dementia or Alzheimer's, so that I don't recognize my loved ones, I don't know what's going on, in the event that I contract some disease or something like pneumonia, for example, and without treatment, I would die. I want to be allowed to die. And so what we put in the healthcare directive is, I don't want antibiotics in that situation. And so most people look at that and they go, what do you mean you don't want antibiotics? It's like, it all depends on the context. You see, if you are, if antibiotics will make you better and, you know, you'll have a quality of life, then absolutely you want antibiotics. But if antibiotics are simply to cure the pneumonia, which would otherwise take your life and allow you to pass peacefully, then maybe you don't want the antibiotics. So the reason to put, you can put whatever information you want into your healthcare directive. The reason we include more of these situations is to help people have more conversations, because the more conversations you can have about it, we really do think it's better. So the healthcare directive comes into effect when the doctor has put in writing, your attending or two treating doctors have put in writing that you are in a permanent or terminal vegetative condition. There are formalities that come with these legal documents. For example, the healthcare power of attorney and the healthcare directive need to either be notarized or witnessed by two people who are not related to you, who are not going to inherit from you, and who are not your healthcare providers. So those are some of the formalities. Now, would your healthcare directive be recognized in the case of an emergency? So this is to help you understand when this comes into play. So an emergency, I guess it depends on what is meant by an emergency. So if treatment can save your life, then your healthcare directive isn't in play. If, for example, you've been in a car accident, you are going to get medical treatment. They're going to do everything possible to save your life. But when the doctors have done everything to say, we've done everything, there's nothing more we can do you want heroic measures, medical, interventions, or excuse me, mechanical interventions to keep you alive, then that's when, if you say no heroic measures, then it's clear that's what you want, and then your healthcare agent will say, no, don't give those heroic measures, or withdraw them if they've already been given, to allow the person to pass. So usually when we're talking about emergencies, people think of this lime green form. This is called a POLST. It's a physician's order on life-sustaining treatment. This is the document that tells emergency responders what to do if your heart stops. This is usually what people think of as the DNR, or do not resuscitate form. So for people that have serious health conditions that are in their final stages of life, or they're suffering from some advanced terminal illness, they may wish to have a PULSE form that says, do not attempt resuscitation. This is not a document that a lawyer provides. This is a document that you get from your doctor after you've had conversations with your doctor about what your situation is. But primarily this is intended to, you put it on your refrigerator, and it's intended for the emergency responders. They come into your house, and if you're not breathing, if they see on it that you've marked DNAR, then they will be hands off. Do you need a PULSE form and a healthcare directive? Really depends on your situation. I do not have a PULSE form. I have a healthcare directive. You may or may not want a PULSE, and what it depends upon is what is your situation. So you definitely need a healthcare directive. Whether or not you need a PULSE, it really is dependent on what your healthcare situation is. So do you need both a healthcare durable power of attorney and a healthcare directive? Absolutely, you need both of those. This is the best protection that you can have to make sure that your treatment wishes are known, they're carried out, you've given guidance, you've appointed somebody that you want to make decisions for you when you can't. It is who will speak for you, that you have chosen, the person you trust, you count on, and what your end of life wishes are. There was an article this week in the New York Times. It was on April 4th, and it was written by a doctor who's treating COVID-19 patients. And, I know a little bit about ventilators. Not only was Dad on a ventilator, but Mom was on a ventilator at one time, and I had to make the decision about what to do when she was removed from the ventilator. So I thought I knew a little bit, but this article really provided so much good information. And so I excerpted some of it so that we could just talk about those questions, because I think it helps, focus it. So for example, what do I value about life? And these are questions that you should be having with your family, with your healthcare agent. If I will die, if I'm not put in a medical coma and placed on a ventilator, do I want that life support? If I do choose to be placed on a ventilator, how far do I want to go? Do I want to continue on the machine if my kidneys shut down? Do I want tubes feeding me so I can stay on the ventilator for weeks? So this is coming from a doctor who's dealing with the real life crisis right now. This is what she is suggesting that everybody should have an answer to. And I know it's tough. And, you know, what's going on today with COVID-19 is that the folks that are in ICU on ventilators, the doctors don't have an opportunity to even do a face-to-face. You don't have an opportunity to see your loved one in the ICU because the virus is too contagious. So, you know, when we were struggling with it back with my dad and my mom, we were in ICU. We were talking to the doctors. But today, you know, it's not even with the physicians are just on the phone with family and trying to get the best information. So I think this is, you know, kind of highlights why it's so important to have these conversations, which is what the doctor's advice is. And so what I highlighted is no one will know what choices we would make unless we tell them. So the takeaway is appoint the person, and I did not write this sentence, appoint the person you want to make decisions for you and let your doctor know your wishes. That came from that article from the New York Times. So, all right. So this is a little bit about other documents, not talking about healthcare, but if somebody loses capacity and if they're unable to make their own decisions, and if the time goes on and it continues and it goes on, somebody's going to have to be in place to take care of financial matters. So not just having a healthcare durable power of attorney, but you also need a financial durable power of attorney. And what that is for is just so that, you know, somebody can pay your bills. And again, has to be someone you trust. Just like when you're appointing the healthcare agent, you need to appoint somebody, what I usually say is somebody you can trust with your money in your life. You need to trust them. Somebody that can manage your financial affairs when you can't, that can pay your bills, manage investments, do whatever they have to do. One of the things that at Elder Law Group that we really focus on is long-term care and how to have get eligibility for state benefits like Medicaid. So it's really critical that when we're helping clients qualify for Medicaid long-term care benefits, that the durable power of attorney for finances has that necessary authority in it. So that's not something that we're going to be talking about today. I just wanted to make sure that we talked about the fact that we need to have a financial durable power of attorney in place. And then, of course, you've all heard of a will. This is not what I call the living document. This is the document that oftentimes people think about when they think about their estate plan, which is their will. What happens when, you know, you pass away? Well, that's what a will is going to manage and make sure that your assets go where you want, to whom you want them to go to. And when we talk about an asset protection trust, and we'll talk about that at a later webinar, this is the best tool that we have to protect either a spouse after you're gone or any beneficiary who might need asset protection, somebody who, even if they're not on government benefits, they might have lifestyle issues or problems, and you know that you, if they inherit, it might be problematic. So this will be the topic for a different presentation down the road. All right. So what I'll check this out in just a minute when we're, well, let me go ahead and move to the next slide here. What I want you to know, and I thought we all needed a little bit of cheering up after this heavy, serious, talk today, is you can take steps to protect yourself, to protect your family, to make things easier in case of a healthcare crisis. Make sure your wishes are known. So, that's, we're all responsible adults. This is, what needs to be done, particularly, in this, this time frame that we're dealing with. So yes, you can take steps to protect yourself. And I wanted to thank you. This is how you can get in touch with us. You can call us. The phone number there is 509-468-0551. You can go to our website, elderlawgroupwa.com. You can send us an email, team@elgwa.com. And so I am going to stop my screen share right now to see if we have any questions that I can answer. So bear with me here while I take a look. All right. So this one question is, how long does it take to get the final documents done? How we're proceeding now is we are, we used to meet in person with people. We're not doing that now generally. We're doing phone calls, we're doing Zoom meetings. All of our meetings that we can do, we are doing, virtually. Typically, from start to finish, everything will be done within a 4 to 6 week time frame. But sometimes, depending on the situation, we have had the situation where we get it done the next day. We meet with the client, they're signed the next day. Why? Because it's a healthcare crisis. We don't like that. We don't like to be in that situation, but you know what? When people need that, because that's their situation, we can accommodate it that fast. But generally, it's a 4 to 6 week time frame. Another question is, can you share, can you email a copy of the recording so I can share it? I will have to defer to my experts, and they tell me, yes, we can. Another question is, healthcare directive, compared to the 5 wishes. The 5 wishes is, if you've taken a look at it, you see that there's a lot of questions in it, like that deal with end-of-life questions, but they also deal with softer issues like, I do or I don't want this kind of music or this or that. Just last week, I was talking to an aging care manager, and she said, what are we supposed to do with the 5 wishes when we have a healthcare directive as well? And what I told her was, the 5 wishes are fine for knowing what their preferences are in what I call the softer areas. And so if they want to use the 5 wishes and just, write down that they want this kind of music, or they don't want this, or they want this, then that's fine. But rely upon the healthcare directive. Now that's when there was a healthcare directive. If all the person has is 5 wishes, then that's certainly better than nothing. Absolutely. But it is not an estate plan, because it will not cover financial durable powers of attorney. It will not cover where your estate goes when you pass. So it's kind of like, in a way, the form that the doctor gave you when you went in for surgery and you didn't have a healthcare power of attorney. It's an interim measure. It is legally honored, the 5 wishes, but it isn't the type of robust estate planning that I would recommend. So other topics that we have planned, and those would include, I do want to talk about the wills, revocable living trusts, what you can do to basically, get your affairs in order so that, let's say, if somebody were to pass away, how do you make it easier on your family? Doing an estate plan is one of the greatest gifts you can really give to your family. Maybe you've had a situation where you've dealt with, they didn't have an estate plan, and you had to basically, take care of, a loved one's matters after they passed. It can be just difficult, heart-wrenching. So we are going to be covering more topics that have to do with estate planning. We probably will talk about government benefits planning too, such as Medicaid and long-term care, but that would be after we do the next on planning for wills and trusts. So how we're going to do invites going forward, probably we'll send everybody who attended today an invite for any future meeting. We're doing Facebook, you know, trying to advertise it on Facebook. And I do ask that if, you know, you enjoyed this or you got something out of it, you know, please share this information with somebody so that they can also, you know, learn from today's webinar. So here's a question. Are spouses automatically considered a healthcare power of attorney? No, they're not. So the doctors need somebody to talk to. So there is a statutory authority. So the first on that statutory authority is a guardian. Well, like I mentioned, you don't want to be under a guardianship. That's a situation to avoid. All right, so let's say there's no guardian. Who's next on the order of priority? Your healthcare agent. Okay, so you don't have a healthcare agent. Who's next? Next would be your spouse. So that is how a spouse does have legal authority, even without being designated as a healthcare agent. But do keep in mind that that works for medical situations, but it doesn't work for financial. The next after that, under the statutory authority, is your adult children, all of them. So there's none, say, of the oldest and then the next and the next. So that's where we can really run into problems of the committee type situation that could lead to a guardianship. Definitely documents need to be witnessed. These documents that we've been talking about today, your healthcare power of attorney, your healthcare directive, need to have 2 witnesses or be notarized. So to gather up documents to prepare for any meeting, we like to see your prior estate planning documents if you have any. And if you don't have any, then that's fine. Then we just will talk with you about what your situation is. So don't get bogged down by saying, oh, I've got to do all this preparatory work before, you know, you reach out to the law firm, because you don't need to do that. We will post fairly quickly when the Will with Asset Protection Trust webinar will be. I can't give you the date, but within the next couple of days, I think we'll know what that date is. Next question, do you really need a will in a community property state like Washington, and why? Great question, and that's exactly what the topic of the Will with the Asset Protection Trust is. So stay tuned, we will definitely go over that. But that's not something I can answer today. I know we're coming up on about 10 minutes to the hour, and I want to make sure that I answer everybody's questions. How do you schedule a one-on-one meeting with the team? Just give us a call or go to our website. We have a contact us form. If you want to give us a call, again, it's 509-468-0551. So I want to thank you all for attending, being here. Thanks for watching. Everybody, you know, do that social distancing, stay healthy. I know we're all in this together, and we will all get through it together. So again, thank you so much, everybody. And I'm going to go ahead and sign off now.